right, so Henry Akina joins us. He's the National Legal Advisor Committee for Defense of Human Rights, at CDHR. Good morning. Thank you for joining us on the program today. Well, we've seen a lot being said and some being done about the political scenario in Rivers State. I mean, ever since then, the governor has said no price is too big to pay for peace. We've seen the state lawmakers go ahead, sit. They've withdrawn the impeachment notice. So it does appear as though everything seems to be running in its own direction. To some people in the political class, they're smoothly. But to lawyers, I think quite a number of them, we've heard them think differently about this matter. So tell us, what is your impression of how things are panned out so far?
Yes, good morning. Thank you, Chamberlain. Well, it's true that there is no price that will be too much for peace. Peace is priceless. However, there are more fundamental considerations when you want to pursue peace. There may be conditions that will really define whether that approach to pursuing peace is appropriate or otherwise. But so much has actually happened in Rivers State. Our worries have been heightened, and our concerns reasonably so. But what's important really here is the political crisis in Rivers State are actually really disturbing in terms of the development and progress in the state, the expectations of the people with respect to good governance, and then the primary responsibility of government as provided in our constitution under Section 14, which essentially is to continue to enhance the welfare of citizens and then ensure the protection of lives and property. And then when there are these distractions between and amongst the political leaders and public office holders, the legislature very important, which is the foundation of democracy, and then the executive, which is the veritable tool for executing government programs, then it's quite obvious that there will be challenges in development and then the expectations of the citizens. But the issues of law that I've observed and I've actually come clear on these matters are fundamental because they are constitutional issues. We cannot purport to pursue peace and at the expense of extant constitutional provisions. And more so, when those who are at the center of all of these skirmishes are actually political office holders that have taken sworn to oath in this country. Every governor of the 36 states of the Federal Republic of Nigeria has assumed office after swearing to an oath to observe and protect and uphold the provisions of our Constitution. And that would mean that in any engagement, any interaction, any relationship you would have as a governor, what must define and determine your approach to that pursuit would be the provisions of the Constitution. There is no compromise about that. The same applies to the President of the Federal Republic of Nigeria, who also has sworn to the oath of office to observe and obey and protect the provisions of our Constitution. It would mean that even when you're acting as a mediator, but of course, assuming that position as the President of the Federal Republic of Nigeria, you must observe and protect the provisions of our Constitution. You can't undermine or overrule those provisions. The same applies to legislators, including the legislators elected to the Rivers State House of Assembly. Yeah. So these are very critical concerns, and I think that across the country, everybody has spoken about these issues.
So tell us, for those who argue that there is alternative dispute resolution and that this is part of leveraging on that, do they have a point?
No, Chamberlain, I'm afraid they don't. There is no consideration or provision in any section of our Constitution that talks about alternative dispute resolution. It's a veritable strategy for dispute resolution, no doubt. It's encouraging, no doubt. But it remains the fact that you cannot pretend to be resolving any dispute amongst disputants, either as a mediator or any other position you occupy in that regard, to subvert or overrule or suspend the provisions of the Constitution. So that argument, I believe, is a weak one, particularly with respect to the provisions of the Constitution. It is not in any way to undermine the advantage of alternative dispute resolution in any dispute amongst disputants, really.
Mr. Kine, can you tell us precisely, what areas of the Constitution you think have been breached here through the alternative dispute resolution, assuming there were any?
Yes, Mark, our Constitution is very clear to the effect that the powers vested in the governor of a state to constitute his cabinet are exclusive to the governor. And that will mean that there is no mechanism or no consideration whatsoever that anybody will assume any power to direct a governor who to appoint to constitute his cabinet. And that I mean appointment as commissioners or special advisors or any other position. It's exclusive to the governor, just as it is to the president of the Federal Republic of Nigeria. And being a constitutional matter, even when you're determining any issue in any mediation that relates to the powers and functions of a governor as provided in the Constitution, then you must be guided by the provisions of the Constitution and be very firm at that. It doesn't matter who is involved. So when it came to that point, you would have simply told everybody who was in the meeting that, yes, when it comes to the issue of commissioners of a government, particularly the government of Rivers State, that nobody can do anything other than allow the governor to exercise his constitutional power. And anything other than that is interference. And interference with the functions of the governor of a state with respect to the provisions of the Constitution is a violation of the provision of the Constitution. And that's one. Then another is where Section 109, which has become the most of the talking point in the last weeks in Rivers State, is to the effect, particularly subsection 1, paragraph G, which no doubt and unarguably, even the affected 27 legislators admit to that fact and uphold that position up till now, that they have defected. They are not mincing any word. They are not pretending. They said that to the governor, to the president, and after that meeting, even as at yesterday, they assert that position, that they have defected from the People's Democratic Party, which is the political party that sponsored them to office, and they have moved to the All Progressives Congress. And this is a very serious constitutional matter. We have had this mischief in this country that legislators will, at will, and as often as they will do so, move from one political party to another. If we continue this way, you'll find a situation where they will move in, move out, cross carpet, and recross carpet. Then the Constitution went on to avoid this mischief and then insisted that you must not, if you do that, if you vacate, then of course, if you so defect, then you vacate the seat. And when we even observe the purported excuse that the legislators in Rivers State, those gentlemen, 27 of them, alluded to the reason, even as up to yesterday, when one enemy judge was speaking, I think it's on your platform, he was actually saying, oh, we elected the president, we supported the president, and so we have to move on to the party of the president to help him succeed. That is no ground known by our Constitution to justify the defection from a political party that sponsored a candidate, so an elective position, and then to another and retaining that seat. That is not known to our law. So that would simply mean you jettison the Constitution, you throw the Constitution away, or like a military junta, you suspended the Constitution and had other considerations to justify that defection. So it's a clear violation of the provision of the Constitution. Everybody's spoken up to that, that whatever resolution it will be, that you would justify that constitutional infraction. That's unfortunate in a constitutional democracy. And then another issue, again, is the issue of law. When a House of Assembly has properly taken through the stages of lawmaking, and then they have enacted a law, it is only known that it is the court that will test the veracity or appropriateness of that law otherwise, and then either sustain that law or pull it down. And where the Rivers State House of Assembly, it remains on record that the Rivers State House of Assembly had received the appropriation bill from the governor. And the process started with the governor considering the appropriation bill in draft at cabinet with his commissioners. And then when they presented that bill before the assembly, it is only presumed that that law remains valid until pulled down by the judiciary. And then that law had taken the stages. They said the first reading. We are not members of that house. I believe that the members of the River State House of Assembly that remained at that time had read that bill the first time, had gone into the second reading, constituted themselves perhaps as committee of the whole, and may have considered the bill clause by clause, and then gone through the third reading, transmitted to a governor, and he has sent it.
Mr. Ikine, it's very interesting that you point out the parts of the Constitution which you say, invalidates or says that those who have defected as lawmakers need to vacate their seats. But we also know that I think parts of the Constitution also say that it is the Speaker who directs them to, move or to vacate their, who announces that those seats are vacant. Because only yesterday, at the level of the National Assembly, it was only yesterday when a new senator was sworn in that we heard that the seat, which had been occupied by the current Minister of Works, I think Senator Dave Umahi, was just declared vacant, and that was given effect to by the Senate President. So if that is the rule, that is the way it works, even at the national level, the question is, how did the Speaker in the River State House of Assembly, who declared the seats of the 27 people vacant, emerge? Under what circumstances did he emerge? Yes. Is it possible for four lawmakers to just be on their own? Four lawmakers whom we had heard had been suspended initially by this same House, be on their own and say, we've elected a Speaker among ourselves, and then these four lawmakers receive a budget, and under 24 hours, a budget is passed, and we say, it's only a court that can, invalidate that sort of law. Doesn't it also turn the law upside down and turn the law on its head?
Yes, thank you, Mekwe. This is very important, and that's why I'm here, to the best of my knowledge. No, it doesn't, and let me take them one after another. Clearly, the Constitution of the Federal Republic of Nigeria established a House of Assembly for each of the respective 36 states of the country under Section 90 of the Constitution, and River State has one. And then the Constitution went on to say, in considering the constitution of creation of a House of Assembly for any state, that is to assume that if a new state today is created in Nigeria, for INEC to delineate constituencies, state constituencies, it should not be less than 24 and shouldn't be more than 40. That established. That, let me quickly state, is only in respect to the creation of a House of Assembly and then the delineation of the constituencies. That established. I'm laying this foundation so that when we get to the issue of the four, we would have gotten this very clearly understood. Now, you have also the Constitution extant that there shall be a Speaker for each of the 36 houses of assembly. River State has a House of Assembly, and there has a Speaker, and there shall always be a Speaker at all times. Now, what has happened in River State House of Assembly was that some 27 members, remember, including, assuming without conceding though, that Honorable Martin Ameule was the substantive Speaker at the time, but it's on record, and you would agree, that himself, that same self-Speaker, also defected. So like the other 26 and himself, if it is true that Section 109 of our Constitution should be given credence, then it meant that he also has lost his seat. So Martin Ameule and the other 26 members who defected, I still hold my strong position and view that they had lost their seat. So let us assume that some four other members, they remain members of the House of Assembly, howbeit purportedly suspended. And let me pose a question. If a school has 10 student population, and then 5 were on suspension, and then 5 were expelled, how many are left as the students of that school? It is the 5 that were on suspension. Because on suspension, you're still a student of that school. But those expelled and rusticated are no longer students of that school. So there were 4 members of the River State House of Assembly. The River State House of Assembly didn't go extinct. Controversially, there were 4 members. And then when that opportunity arose, and don't forget, supported by a decision, or rather a ruling of a high court in River State, gave credence to 4 members. So at some point we had, and we still have, for me, and that's my position, we still have only 4 members of the Rivers State House of Assembly. And is that permissible or acceptable in our constitution? Yes, Maupe and Chamberlain. The constitution didn't say that.
Barrister Kine, if I may come in there, pardon me. Even if the 4 lawmakers who were suspended remain the valid members of the River State Assembly, it would seem from what you're saying that they are all complicit in turning the law on its head. Either the 26 lawmakers who defected and as a matter of law have lost their seats, or the 4 lawmakers to whom the state governor presented the budget. But why do you think the governor is going ahead with this agreement, even though it's alien to the law, according to what lawyers are saying? Is it a matter of self-preservation? Because we would assume that the governor has lawyers who are advising him.
Yes, thank you very much. And just as we assume that the President of the Federal Republic of Nigeria has lawyers, not just in his cabinet, but has lawyers who advise him, and has the Honorable Attorney General of the Federation, whom I even expected should have been in that meeting, because considering the issues they were going to deliberate in that meeting, they were constitutional and legal issues. So the Honorable Attorney General of the Federation ought to have been in that meeting, ought to have had a closed-door consideration of these issues with Mr. President, and ought to have advised Mr. President. And that's why we're having these kind of situations in this country. Sometimes it actually aches one, really, when you see that things happen this way and we get talking. Now, I was laying a foundation which would really give a perspective to how Mr. Governor may be justified to appear before a House of Assembly. Mr. Governor is not a member of the River State House of Assembly, and then he would only await when a House of Assembly accepts his communication to them to appear before a House. The same applies to the President for any business, whether to present an appropriation bill. So it will mean that the governor had communicated the River State House of Assembly. Remember that I said there has never been a time that the River State House of Assembly has ceased to exist. We have only had internal skirmishes within the River State House of Assembly. It started with the issue of the tussle to the leadership, who is the Speaker. Both Martin Sameule and Edison Ehie acclaimed themselves at different times to be speakers. And don't also forget that Edison Ehie has proclaimed that he has been elected even before the defection of these 26, 27 members. And then there is a court ruling that seemed to have affirmed his position as the Speaker. So there is a House of Assembly. Is it properly constituted in terms of members? Yes, I have said that the Constitution did not envisage any situation expressly where a House of Assembly may deplete or to about even one person. Yeah. And can there be such circumstance? Yes, it may not have happened. There may be 32 members, and then all 31 may have a situation that, unfortunately, perhaps, they die. Because the circumstances you may cease to be a member of a House of Assembly or any legislative house could be death.
Perhaps one of the challenges that we're dealing with here, you know, for instance, maybe just to begin, would you say that there has been a quorum in all of the issues that have been raised on the floor of the House with these 4 members? If you can respond to that in 20 seconds.
And the simple answer is yes. And maybe if I need to justify that so that those who would have said, what is this gentleman saying? Yes, in the sense that the Constitution of the Federal Republic of Nigeria, the drafters were very careful to have just said the quorum for any legislative house shall be 1/3 of members. It didn't say 1/3 of 24, 1/3 of 40, or 1/3 of 32.
And you don't see anything wrong with that one. Anyway, but the question that I'd really love to ask you is, I mean, given the interventions that have come on this matter from various quarters, there are those who said that what the River State situation required was a political situation, not necessarily a legal, situation and all of that. Of course, political situations within the ambits of the law. Amakwe asked you that question the other time, whether or not the president indeed broke any law or breached the constitution in any way. So would you say that this is a political intervention to stave off further breakdown of law and order, or it is something that's just been done to arm twist the law?
I may be afraid to ask, what is political solution with respect to any provisions of our law? There's no such thing. Sometimes when we want convenience, we create things that don't exist. In a constitutional democracy, What governs everything we do as far as government is concerned? It's not community meeting, for goodness sake. What governs everything we do as far as institutions and authorities of government are concerned? That's the reason we have the Constitution. If the Constitution and the provisions of the Constitution cannot address them, then the courts should do so. Nothing like political solution. I am not undermining any disposition to peaceful resolution to any dispute. But what is that dispute? Do you know, in law, as lawyers, there are certain matters that are best decided in court by full litigation, where certain declarations will be made that you cannot, by way of probably settlement and arrange the issue of title to land, for example. So for me, and I still submit, that once the constitutional issues arose, it shouldn't have been political. Who are we actually trying to pamper here? Was there any individual who is above the state? What is the rule of law?
But Barrister Kine, a very quick one here. If, in line with the agreement brokered by the president, all court cases are withdrawn, will that mark the end of this conversation we're having?
I'm afraid it may serve the interests of some individuals, but it wouldn't. And why I say it wouldn't is, and that's even the best way for Nigeria, it shouldn't, because otherwise we are laying a precedent where our constitution will, at will, be suspended even in the democratic regime, and then apply any discretion, and then it becomes acceptable. So I think that it shouldn't, so that we continue to insist that our constitution should guide every step that our authorities must take. If you withdraw, claimants and litigants, that is, those applicants go to court and file notices of withdrawal or discontinuance of their suits, does that change the position that where legislators defect without considering or complying with the requirements of constitution, that they have lost their seats? We can't cease to turn that. It shouldn't be an exception in the case of Rivers State. Will that change the situation where a law that has been validly passed should be reinvited and then reconsidered because a president directed it should be so? Would that change the position that the governor's power to, on his own, decide who to be appointed?
When people say, for instance, when you say a president directed, and then they go all out, the people that were all in the room, are they babies? They could either say yes or no. If they feel that this is not it's not what they want, they just say, no, this won't happen. And then they move on and say, listen, we won't violate the laws. But if they call all out and say, okay, we'll comply with this, what then do the people do?
Chamberlain, let me quickly also bring this to another point of law. I'm afraid I'll be speaking strongly more on law. Chamberlain, it is our law that you cannot enter into agreement for any common purpose to violate any provisions of our constitution, even if you are 1,000 of you in that room and you all agree unanimously. So these are the issues we have to look at critically. I don't know what I'm faulting, really. Even if the entire community congregated at Asurok and then agreed to violate a provision of our constitution, would we say because they all agreed to it?
So
this is a constitutional democracy.
We'll then say that, fine, if that's the case for a lot of people, then we'll be looking to see how many lawyers will go to court to challenge some of these things, to correct these ills if they perceive so. So those are the things that society expects lawyers to do.
Exactly. You now have spoken to my direction of thought. This is what we should do as a nation, including the media and everybody.
This is not the first of this kind of scenario. We don't see these things happen. So that's why people keep wondering. We've seen several scenarios. I mean, you say justice must not just be done, but must be seen to have been done. And then they see certain things happen, and then the same judiciary, and they tell you, well, that is the law. So sometimes you just wonder what people are faced with these days.
Chamberlain, I agree with you absolutely. And that's why I recall that it was on the 10th of December, on a Sunday, when we issued a press release on our press conference in commemoration of the World Human Rights Day. We made a point that the judiciary in this country, and I make bold to still say it even on national TV, that the judiciary in this country has been murdered and probably only awaiting interment, burial, really. Murdered in so many ways. It's unfortunate that these are the kind of situations that we should have had the judiciary to stand firm. But what we see, including my colleagues, we file suits, we file all kinds of suits, even in courts of coordinate jurisdiction, and then conflicting orders, even as we continue to condemn those instances, and granting ex parte applications to the extent that will very enormously affect the substantive prayers. These are the issues in the judiciary. But then that would not deter anyone who is determined to uphold the provisions of our Constitution. And I am one that the Constitution is supreme. And when we keep saying rule of law, let our viewers understand what indeed is rule of law. It's the predominance of the law, the supremacy of the law, as distinguished from mere arbitrariness, which is what is playing out. Right. And it's also separated from mere discretion of any individual. Even if you hold the highest office in this country, the rule of law must prevail.
All right, we'll have to thank you for coming on this morning, Mr. Henry Ekine. We'll be back in just a moment. Remember that...
Thank you very much for having me.
Thank you. So we'll talk next about that slash, the Christmas slash for transport fares. Yeah, that's where your views will come in, so don't go away.